Hello everyone, welcome to yet another session of the daily news analysis by SRIRAM'S IAS, where we take up the important articles featuring in the Hindu newspaper and break them down for our understanding from the examination point of view. Let's start today's discussion by taking the important articles. The important articles that feature in the New Delhi edition of the Hindu newspaper are on our screens, and let's discuss them one by one. The first article which appears on in the newspaper reads, "The private sector boost in India's space industry." Now this is a very important article with respect to the privatization that is being introduced in the India's space sector, and the latest development in this arena is the announcement of the heralding the India's new space policy. So the Department of Space is going to promulgate a new Indian space policy which would have provisions for privatization of India's space sector. So privatization of India's space sector becomes a very important topic for us, and we study this from the perspective of science and technology, which we have in GS3 for mains and in prelims as well. So the topic which is important is about the privatization of the space sector. Now what do we mean by privatization of the space sector? So generally when we talk about space sector activities in India, ISRO is the body that we hear about a lot, that they sent a satellite in space and other various things as well. So what is ISRO? ISRO is a national arm of the government, which is known as Indian Space Research Organization. So this is a national body. This is a government body which is working for the betterment of space activities in the country, which is taking care of all the activities. So it is ISRO which manufactures everything, which indulges into the research of all the technologies, then it takes care of the launches, it makes the satellites and it launches the satellites. So all the missions that we see, Chandrayaan 1, 2, Mangalyaan which is to come, all of these are initiatives done by what? ISRO. So it is, and this organization in the past many years we have seen that has shown tremendous success, which has brought India onto the larger map of the world space sector, and India is currently the 6th largest player in the international space sector, and this has happened because of the efficiency of ISRO, which is known for its cost effectiveness. Where other countries perform their space missions with a lot of budget, ISRO has been able to do that with comparatively way lesser budgets and achieved similar feats. So this has been the success of ISRO and the India space sector up until now. So what should be the next step now, when India is continuously growing in its space technologies, capacities and ambitions? It now becomes important for, apart from the government body working in the space sector and bettering the space sector, now the private sector should also equally come in. Much like we know in the country of USA, there is a company called SpaceX, which is run by Elon Musk, which is a private company wherein they manufacture rockets, launchers privately. So such initiatives are now also being targeted in India, where such private players indulging into manufacturing of satellites, manufacturing of the vehicles, all of this should be done in the private sector as well. So Indian government is keen on specially pushing this private sector participation in the Indian space sector, and that is what is meant by privatization of space. So why is it important? When we saw that after ISRO's success, why is private participation in the space sector required? So as we saw that India is the 6th largest space player in the world, but the Indian industry has a bare 3.6% share in the rapidly growing space economy, which is already worth at least $360 billion. So what can we see? That despite India's good performance, India is growing well, but out of the total $360 billion space industry, how much share is India having? Barely 3.6%. So this is something which can definitely be improved upon. So this highlights the need that apart from the government player now, the private player should also come in and give their bit. So only 2% of this market is for rocket and satellite launch services, which require fairly large infrastructure and heavy investment. The remaining 95% relates to satellite based services and ground based system. So we can see that these satellite-based services and ground-based system, a lot of these can be indulged into by the private players as well. And when we talk about the global scenario, if India holds 3.6% share, which country holds the largest percent share? Obviously, it's the US, which holds the leader spot, housing 56.4% of all companies in the space tech ecosystem. So currently, US is also leading in the private sector participation in space, where it holds 56.4% weightage. And other major players include the UK, which has 6.5%, Canada, which has 5.3%, China, which is 4.7%, and Germany, which is 4.1%. These are what? These are the counts of how much share the countries are having in the total space tech industry, right? This is the weightage of all the countries. Now, and when we compare the budgetary allocation, so this is a startling fact where I was talking that why India's space industry has been successful. So US space budget for the last year has been $41 billion. US has assigned $41 billion as its budgetary allocation towards this space sector, out of which 23.3 billion has been focused completely on NASA. And as compared to this, how much does India allocates to its budget? So India's total budgetary allocation for this year, financial year 2022 to 2023, towards the Department of Space, this is the Department of Space which houses ISRO, was 13,700 crore rupees only. So we can see the massive difference with which both organizations and both countries operate, and within this constraint as well, ISRO has been able to come out successful with path-breaking technologies and successful ventures out of space. So that has been the success story of ISRO, which the Indian space industry is now asking the private players also to come and emulate the same success. So now, what are the reasons now that after all this, the space privatization is required? So Indian industries do not have the resources or technology to undertake independent space projects of the kind that US companies such as SpaceX have been doing or provide space-based services. So one problem that occurs is that the particular technologies that are required, which ISRO promulgated, those the private companies do not have, and the demand for space-based applications and service is growing even within India, and ISRO is unable to cater to this. So another reason why private players should come in is because the demand for space-based application is increasing, and ISRO alone will not be able to target this. And the need for satellite data, imageries, and space technology now cuts across sectors, from weather to agriculture to transport to urban development and more. Now this is a very important point which highlights the need for such satellites and space participation. The fundamental question we should ask first is, why do we need satellites and increase participation of government as well as private players in space? It is because the increasing number of satellites that we are sending in the space have immense amount of uses. They have their uses for connectivity, and the data that is collected by these satellites can be of help in making climate resilient system, analyzing the weather, analyzing agriculture, making maps, right? We know that the satellite maps are dependent on the satellite data that is being transmitted from the satellites. So it is because of the multifaceted use in all of these sectors that the presence of space technologies has become increasingly important, and that becomes another need for the private players to pitch in. And there is also a need for greater dispersion of space technologies, better utilization of space resources, and increased requirement of space-based services. So this is the need for private players coming into the space tech sector. Now, what has Indian government done? The current news is saying that Indian government is going to bring a Indian space policy. But is this the first step towards encouraging private participation in the space sector? No, this is not the first step. Earlier also many steps have been taken, the most significant being the establishment of InSpace. Now this is an organization which was launched in June 2020 last year. 2 years ago, right? So in June 2020, Indian government launched the in-space organization, right? What is in-space? It is supposed to be a facilitator, also a regulator. So basically this is a separate body formulated by the government to take care of the private sector, space private sector, to regulate them, to coordinate between them. So it is supposed to be a facilitator to them. So as the problem we saw, that the private companies are not privy to the technologies and they do not have the technologies. So facilitating them with the technologies, coordinating them, regulating them, all of this would be done by the in-space. What is the full form of in-space? Interface between ISRO and private parties. This is the full form of in-space. It will act as an interface between ISRO and private parties and assess how best to utilize India's space resources and increase space-based activities. So this is a premier organization that has been launched and it has already started working. So it is the second space organization created by the government in the last 2 years. So before in-space, there were two public sector enterprises that were created as private players to delegate the functions of ISRO. What were they? First was the New Space India Limited. In 2019, the government launched it, which is a public sector company that would serve as a marketing arm of ISRO. So as we saw that the burden of ISRO, it kept on delegating its other functions to other entities. So it formed a public sector company known as New Space India Limited, especially for the marketing purposes of ISRO. Then another corporation which ISRO formed was the Antrix Corporation, which is another PSU working under the Department of Space, will be handling ISRO's commercial deals for satellites and launch vehicles with foreign customers. Now, how does Antrix Corporation or what we also call Antrix in Hindi, it is named after that. So this corporation deals with the commercial deals that happened with ISRO and other countries. So we also know that when India or ISRO launches the PSLV or GSLV vehicles and transports the satellite load, it also carries the satellites of other countries as well. Those countries who do not have the power to send their satellites and they do not have the vehicles, they take help of other countries' vehicles. So ISRO also indulges in sending other countries' satellites to space. So which corporation will take care of those deals? The Antrix Corporation will take care of the commercial aspect of these deals with ISRO with other countries. So these were the two companies that were set up before in-space, and now in-space has been set up to become a facilitator and regulator. So what are the other important advantages of in-space? In-space becomes a very important organization from a perspective of prelims as well. So it is a significant step in the space sector development in India, where it will provide a level playing field for the private companies to use Indian space infrastructure. So instituting a regulator in the sector, facilitating coordination and facilitating technology advancement will help the private sector. Then these reforms will allow ISRO to focus more on new technologies, exploration missions and human spaceflight program. This is one of the most significant advantage of delegating the other functions, is because when ISRO up until now, which was functioning the bulk of the functions in the space sector, if it delegates other sectors such as, let's say, the ISRO currently, like we saw for the commercial deal, it delegated its function to one corporation. Then dealing with the marketing of the projects, it delegated the function to another corporation. Now the job of manufacturing satellites, something which SpaceX does, can be delegated now to private companies. So what will ISRO do now? Now ISRO would be able to focus on the research and development aspect and focusing on the crucial path-breaking aspect, since it is now free to work on all of these. So focusing on new technologies, exploration missions and human spaceflight programs, attention and space will become, room will increase for ISRO to indulge in these activities. And allowing industries and others like students, researchers and academic bodies greater access to space assets would lead to much better utilization of Indian space resources. So this is all opening the space industry for other players also means that other people can also take advantage of it, and in space will attempt to enhance the activities including access to space assets, data and activities. So also the space data also which is extracted via the satellites, that will also be available to the private companies, and it will propel the Indian industry as an important player in the global space economy, which we established earlier that India currently only has 3.6% share. And there is also an opportunity for large scale employment in the technology sector and India becoming a powerhouse. Now, needless to say, if the economy is rising, if the private players are making a bigger presence, it will also increase the employment in the sector. So these are the benefits which in-space can bring in, and in general the privatization of the space sector which Indian government is targeting will bring in. But are there any challenges to privatization of the space sector? Before we come to challenges, let's take up the current scenario which is highlighted by the article. So in these developments in the past many years, what is the current status now? So this article highlights that the Union Minister for State for Science and Technology had stated earlier that the 60 odd startups, now currently the startups which have arrived in this private space sector has reached up to a number of 60. So there are 60 companies now working in the space tech sector, and a majority of them are dealing with projects related to space debris management. What are space debris? Space debris can be called as those junk material of the satellites earlier spent. Whenever a satellite is sent in the outside Earth in an orbit, it performs a function for certain years, then after those years it becomes defunct. Now what to do with that satellite? It has become defunct, it's of no use, so being out of Earth, it keeps revolving in the space. So this defunct satellite can be a cause of concern if other satellites come in contact or collide with this defunct satellite, or it goes on to harm anyone or any other satellite or any mission. So this particular defunct satellites and many such defunct satellites and other bodies which are sent to space and they become defunct are known as space debris. And this is an emergent problem in the outer space, which say that increasing satellites being sent in the outer space, apart from that, the debris or the junk which is also created by the past satellite also needs to be managed. So majority of India's startup are coming in the space debris management sector. And with respect to the increasing funding into the sector, startup in India nearly tripled to 67.2 million on year-over-year basis. So this data shows a positive step or development in the direction of privatization of the Indian space sector, right? So now what can be the advantages of privatization? As we saw, it will help give the Indian sector the boost and pace which we saw. ISRO will get spare time to indulge into other activities, and private players can take up routine and commercial activities, launching weather and communication satellites, helping ISRO, right? And the economic benefits are immense in the future, which can be shared by the private sector and ISRO, which we saw. The economy can be increased, large scale employment can be introduced in the private space sector. Now coming to the challenges. What are some of the challenges that exist in the privatization of Indian space sector? First is the extensive brain drain from India is significant in space and aerospace sector, mainly because India is still a marginal force on the global space platform. Now this currently is a challenge to privatization because the manpower that is needed to channelize India's industry, most of it is draining from India, where most people go abroad. Now the privatization can also become a positive step in this direction, where the brain drain can be reduced. If the presence of private companies increase in India itself, the brain drain can be reduced as well. The next challenge is that there are a lot of policy bottlenecks which make it difficult for private space companies and entrepreneurs to acquire investors, making it almost impossible to operate in India. This policy bottlenecks is what the new Indian space policy, which is to be launched in future, should be looking to deal with. And the absence of a framework to give openness and clarity in rules is one of the reasons for the lack of independent private participation in space. So again, this is a problem, and the organizations like InSpace has been done to deal with this. And another critical aspect is the absence of space law, insurance and indemnity clarity, that which organization assumes obligation in the event of a mistake. As we saw, the concept of space debris, many accidents can happen while sending such satellites and other equipment to space. So there is an absence of such laws as to who will be dealing with all of these things. So it is very necessary that if we are bringing private players into the sector, so we make these laws of liability, indemnity and all of such provisions very clear for these players, so that they are aware of the provisions. So this should also be addressed in the space policy. And many private businesses are already active in equipment and frame fabrication using either outsourced specs or lease licenses, which means that already certain private businesses are in the sector but are working in the equipment and frame fabrication, or what can be said as the lesser activities, where they can now elevate to satellite manufacturing and other aspects as well. So this was the discussion relating to the privatization of Indian space tech sector. This becomes a very important topic because the government is taking a lot of steps in it, and we can expect a question in the mains examination on this basis. So with this, let's move on to our next article for the day. The next article which appears in the newspaper reads, "Plans are on for India to host world-class sports event," says Thakur, or this is Anurag Thakur, who is the Union Minister for Youth Affairs and Sports. So now what is important in this article? The article features an interview with the minister where he talks about a very critical scheme known as the TOPS scheme, or Target Olympic Podium scheme. Now what is this scheme and why is this important? First of all, the questions on sports have now become very important. The prelims, 2021 prelims saw a few questions on sports, and in general also, especially the Indian government and the current atmosphere and climate in India, that a lot of focus is being given on sports, where the government itself is launching the Fit India campaign and introducing physical development in the country, encouraging fitness and physical development in the country. Similarly, it is also pushing for medals in the Olympic and other such world level championships. In order to increase India's position in the sports, global sports order as well, India launched the Target Olympic Podium scheme. Now this is a special scheme which is being set up by the Ministry of Youth Affairs and Sports. That is the Ministry for Sports in India. So it was launched by the Ministry of Youth Affairs and Sports to facilitate these players, those players who hold the extreme capacity to bring medals for India. So how can the Indian government facilitate them in providing them various facilities and supporting them? That was the scheme for Target Olympic Podium scheme. So what does this scheme say? Let's take a look at it. In order to improve India's performance at the Olympics and the Paralympics, the MYAS, or Ministry of Youth Affairs and Sports, started the Target Olympic Podium scheme in September 2014. Now what does it include? It includes foreign training, international competition, equipment and coaching camp, besides a monthly stipend of 50,000 for each athlete. So currently, as most of us must have seen, Neeraj Chopra has won a silver medal in the World Athletics Championship. So a few months ago, he wanted to train in USA at a specialized training agency, and he was not able to procure a entry into that sport facility. So it was granted to him, a special access was granted to him with all facilities made possible under the TOPS scheme by Indian government, and he was able to train in that facility. And so this was granted under the scheme where the athletes get foreign training, they are taken care of all the facilities that is given to them. So this is done under the TOPS scheme. It was particularly launched for India's Olympic medal dream at the 2016 Rio Olympics and 2020 Tokyo Olympics. So can we say that it gave a good result in the Tokyo Olympics, right? India's performance at the Tokyo Olympics was very good. So whenever we look at the good performance, a lot of such schemes are at the backdrop of it supporting all of such results. So that is why this scheme becomes very important, which can definitely be asked in the prelims examination. So how does this scheme function? The Mission Olympic Cell is a dedicated body created to assist the athletes who are selected under the top scheme. The MOC or Mission Olympic Cell is under the chairmanship of the Director General, Sports Authority of India. So again, Sports Authority of India, the Director General of the Sports Authority of India is the chairman of Mission Olympic Cell. The idea of these MOC is to debate, discuss and decide the processes and methods so that the athlete receives the best assistance. The MOC also focuses on the selection, exclusion and retention of athletes, coaches, training institutes that can receive the TOPS assistance. So currently a few athletes get the assistance under this scheme, and this Mission Olympic Cell will decide on all these services. Who will be the coach, how much assistance will be given, when it is to be given, all will be decided by this body, which will be chaired by the Director General of Sports Authority of India. So these are the important points that should be remembered with this scheme, and with this let's move on to our next article for the day. The next article which appears in the newspaper reads, the latest guidelines on arrests and bail orders. Now, this article is important in the current context where we are seeing that a lot of arrests are happening, which are even debated to be debated to happen willingly against intentionally against adversaries. So a lot of people are facing the problem of indiscriminate arrests, and therefore the case went to Supreme Court, and recently Supreme Court has given an order saying that the bail should not be granted in such a proficient manner, and the jail is an exception and bail is a norm. What does this mean? That granting bail, it should be the rule, and jailing some person should be an exception. So what should be done more is granting bail, and what should be done sparingly or choosing case to case basis on a rare basis should be granting of jail. So this principle has been highlighted in by the Supreme Court in the recent judgment, where we'll take a look at the recent judgment and what is the latest guidelines that the Supreme Court has given. But why this article becomes important is that even the UPSC prelims now is focusing on these everyday important legal concepts. One such example is the question that came in prelims 2021, where the question asked with respect to judicial custody. Now again, this is a legal concept with respect to arrest, which features in the newspaper where we see. So we hear and see a lot about judicial custody, arrest. So UPSC asked a question on that, asking about the nitty-gritties of judicial custody, where judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in a police station and not in jail. And second statement is, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So this was a question asked in prelims 2021. We'll discuss the answer to this in a short while. The point to understand from here right now is that such important legal concepts as well have now come into the focus area for UPSC. So after understanding that, let's come to the question of bail. Now, what is this new SC judgment on bail that has come? So two-judge bench, a bench of two judge, meaning that two judges gave the judgment together, issued certain clarifications to an older judgment delivered in July on bail reform. So the case which is of concern is the Satyendra Kumar Antil versus CBI. In this particular case, the Supreme Court gave out the guidelines that such indiscriminate arrests should not happen, and bail should be the norm and jail should be the exception. The ruling is essentially a reiteration of several crucial principles of criminal procedure, where the judgment and the judges focused on the state of jails in the economy. In one of our earlier articles, we had seen the immense amount of presence of under trials and prisoners in the jails, where the jails is flooded with criminals and it is overflowing with the under trials and prisoners. 2/3 lodged are under trials. Who are under trials? Those people on whom the case is still going on, and they are not being held as a convict, or no sentence has been granted to them. But since the case is going on against them, they are languishing in the jail and are known as under trials. So Supreme Court pointed out that 2/3 of people who are lodged in jail are under trials. So this is such a grave situation that people on whom cases are going on are not getting timely hearings and not getting bails, and they have to languish in jail. So Supreme Court pointed this out and called for reform in the bail application. So theoretically, the court also linked the idea of indiscriminate arrests to magistrates ignoring the rule of bail and not jail to a colonial mindset, where they said that this was a colonial mindset to stifle people and not grant them bail and instead keep them in jail. So this was the ruling of the Supreme Court where they highlighted this issue. So after this, now currently what is India's law on bail? Where does the bail applications for in Indian law flow from? So there are two branches in criminal law. One is the IPC, or what we call the Indian Penal Code, and one is the CRPC, or the Criminal Procedure Code. So now the Indian Penal Code, we'll see a lot of times that he was charged with murder under section 302 of IPC. So IPC is that law in the Indian criminal system which deals with the offences, which will enumerate what offence is counted as a crime and what is the punishment for that crime. That would be mentioned in the IPC. But there are also certain important aspects when it comes to criminal law about procedures as to how will the arrest be made. If the police is going to arrest, what rights do the citizens have? After the arrest, what is the procedure to present the accused in front of the magistrate? What are the provisions on charge sheet? What are the provisions on bail? So these form the provisions of procedure in criminal law. So the procedural aspects are mentioned in the CRPC, which is Criminal Procedure Code. So I hope this distinction is clear, where the offences and the punishment are mentioned in the IPC and the procedural aspects of criminal law are mentioned in the CRPC or Criminal Procedure Code. So the bail provisions as well are mentioned in the CRPC, wherein it does not define the word bail but only categorizes offence under the Indian Penal Code as bailable and non-bailable, which means that the CRPC has two kinds of offences. One are bailable and one are non-bailable. What would they mean? As the name suggests, those offences on which a bail can be granted. The accused, after getting arrested, can approach a court and seek bail. Those offences would be bailable. And some offences are non-bailable, which means that if there is a report on some person having committed a non-bailable crime, they would not be liable for bail. So what can be a bailable crime? A lesser crime or a smaller crime can be a bailable crime. Let's say theft or other such crimes on which bail can be granted would be a bailable offence. And grievous crimes such as that of murder and other such crimes on which bail should not be granted to that accused are forms of non-bailable offence. So the CRPC divides offences into bailable and non-bailable. And the power of granting bail is in the magistrates to grant bail for bailable offences as a matter of right. So those offences on which bail can be granted, the CRPC says that the magistrate has a right to grant bail, and even the accused has a right to receive the bail because the offence is bailable. But what happens generally is that a lot of procedures are enlengthened to even deny bail in the bailable offences as well. This would involve release of furnishing a bail bond. So whenever a bail is granted, what happens is that the accused has to sign a bail bond, which means that he gives in writing that in lieu of certain sum of money, he is going out of jail, and he also agrees to be present at whatever time and period the court and police wants him or her to come. So with or without security, and in case of non-bailable offences now, a magistrate would determine if the accused is fit to be released on bail. In case of non-bailable offences also, if the bail is to be granted, the magistrate would determine if the accused is fit to be granted bail or not. Now, there is another concept which comes in criminal law which is known as non-bailable offences are cognizable, which enables the police officer to arrest without a warrant. Now, what are cognizable and non-cognizable offences? Cognizable offences are those offences of which the police can take direct cognizance. Let's understand it like this. When we often speak of a word called recognize, so that is where the word cognize comes from. And whenever an offence is cognizable, it means that the police can directly recognize this crime and go on to arrest that person without a warrant. And non-cognizable offences are those offences for which the police cannot go to arrest without a warrant. They would require a warrant in case of a non-cognizable offence. So in case of a cognizable offence, the police officer can arrest without a bail. And section 436 of the CRPC lays down that a person accused of a bailable offence under IPC can be granted bail. So section 436 deals with the bail provision, and section 437 of the same CRPC lays down that the accused does not have the right to bail in non-bailable offences, and it is the discretion of the court to grant bail in case of non-bailable offences. So this was the backdrop relating to what is the law that is present in the CRPC. Now talking about the reforms that the Supreme Court has suggested. What has Supreme Court suggested to streamline this process? So apart from suggesting that this indiscriminate arrest should end, the significant suggestion that the Supreme Court has made is that there should be a separate law for bail, where there should be a separate bail act. The CRPC as a whole should not be the only document that should be dealing with bail, and there should be a separate piece of legislation enumerating all the provisions of bail. So it advocates for framing of a separate law that deals with the grant of bail. Why is this important? Because when you have less provisions, there is more ambiguity that is to be followed, and therefore it is seen that there is no set standard. Some judge follows one standard, another judge follows another standard. So there should be uniformity and certainty in the law, which is in the decisions of the court, which are the foundations of judicial dispensation. So in order to ensure this, the judges say that there should be a separate law. Then second one, as we discussed, there should be curbing of indiscriminate arrests. The court noted that the culture of too many arrests, especially for non-cognizable offences, is unwarranted. What were non-cognizable? Of which police cannot arrest without a warrant. It emphasized that even for cognizable offences, arrest is not mandatory and must be necessitated, which means that the arrest should happen by the police on very strong conditions. When they say that it's necessitated, it means that the accused should be arrested to prevent any further crime. It should be established that the accused is dangerous, that he or she might tamper with the evidence. Only when certain conditions are fulfilled should the arrest be made. So these are the guidelines which Supreme Court put forward in case of indiscriminate arrests of people. Next is the bail application, which means that what should be the procedure for filing the bail application. So there need not be any insistence of a bail application while considering the application under section 88, 170, 204 and 209 of the code. Now these sections are not important. It's just that the Supreme Court said that under certain sections of the CRPC, there need not be any instances of a bail application, which means that without an application also a bail can be asked in front of the court. These sections relates to various stages of a trial where a magistrate can decide on the release of an accused. But what it essentially says that it has done away with the bureaucratic requirement of a bail application, that in order to facilitate bail, you need not even submit a bail application in the respect of these certain sections. And it has also given certain direction to states where it has directed them and other union territories to facilitate standing orders to comply with the orders and avoid indiscriminate arrest. So whatever guidelines Supreme Court has given, it has directed the states to formulate its own orders based on these guidelines. And this would certainly take care of not only the unwarranted arrests, but also the clogging of bail applications before various courts, as they may not even be required for the offences up to 7 years. So these are the reforms suggested by the Supreme Court in the aspect of bail reform. Now, can we come to the question which we posed? What is the answer to this? The answer to this is option B. So the concept here that is to be understood is judicial custody. Now we hear two words. One is judicial custody, one is police custody. What is the difference between them? We often hear in news that the accused was taken into judicial custody or the accused is currently into the police custody. So, as the name suggests, when they say that it is judicial custody, this means that this arrest, decision has been taken by the judge or magistrate, and he is under the arrest of magistrate, which means that he will go to jail. And police custody means that the person has been taken by the police, as in is in the police lockup, which we see is in the police station, as we generally see. So that means police custody, and the other one is the judicial custody. So what is this statement saying? Judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in a police station and not in jail. So this is where the statement becomes wrong, where the accused is locked up in jail. And during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So this is also a difference, that because it is judicial custody, the police would require the approval of the court to interrogate. That is why the right answer is statement 2 only. Right? So this is where we finish our today's discussion and we put an end, and we'll meet again tomorrow with the important articles for the day. Thank you.